The verdict was already written. Nadia could see it in the way the judges arranged their papers. The careful, finished movements of people who had already decided. They weren't reading anything. They were performing reading. There was a difference. She had spent 19 years learning to spot it. She sat at the defense table and kept her face very still. Behind her, through the thick transparent wall of the Galactic Court's observation gallery, she could feel 300 beings watching. Delegates. Journalists. Dignitaries. Every major species with a seat on the Galactic Assembly had sent a representative to watch. Nobody sent representatives to watch cases that were uncertain. She opened her case file. Page 1. The charge. Humanity, designated Emerging Species Class 7, is hereby charged under Galactic Code Article 91 with existential contamination. The prosecution alleges that continued human expansion poses an irreversible systemic risk to established galactic order. Remedy sought, Species Cessation Order. Species Cessation Order. The court's language for extinction. She had defended 41 cases in this court over 19 years. She had lost the last 7. The one before that had ended in a mistrial that everyone pretended was a win. Her reputation had a precise shape now. The shape of someone you called when nobody else would take the case. She was the lawyer you hired when you had already accepted the outcome and just wanted someone to make it look like a fight. She turned to page 2. The prosecution was led by Advocate Senvorel. Nadia had researched him for 6 weeks. 400 years old. Undefeated in this court in 11 consecutive cases. He represented the Keth Dominion, the oldest continuous civilization in the galaxy, with a legal tradition that predated humanity's written history by 3 millennia. He sat across the aisle from her now. Very still. Very composed. The particular stillness of something that has never needed to hurry. He had not looked at her once since she entered the room. That was information. When a prosecutor doesn't look at the defense, one of 2 things is true. Either they respect you enough to be cautious. Or they have already won and you are furniture. She knew which one this was. She looked down at her notes. 48 hours. That was what remained before the formal proceedings began. The court's mandatory deliberation window. Designed, 6,000 years ago, to give defense teams time to prepare final arguments. In practice it was a formality. Nobody had successfully used the deliberation window to change an outcome in over 200 years. She had one argument. 1. She had found it at 3 a.m. 4 days ago, buried in a footnote in a procedural archive so old it wasn't indexed in the modern system. She had almost missed it. She had been awake for 31 hours when she found it and she had read it 4 times to make sure she wasn't hallucinating from exhaustion. She still wasn't sure she wasn't. She closed her file. She looked at the bench. 7 judges. 7 species. All appointed by the Assembly. All perfectly neutral by every official measure. One of them, the judge on the far left, a Murith elder named Provisional Seat Holder Varnsale, had blinked twice quickly when Nadia sat down. She filed that away. The pre-session briefing lasted 40 minutes. Charges were formally read. Defense acknowledged receipt. The prosecution submitted 112 supporting documents. Nadia submitted 9. She heard someone in the gallery make a sound when her document count was announced. 9. Against 112. She kept her face still. After the briefing she was escorted to the defense preparation suite. A small room. Functional. A table, a terminal, a narrow window looking out at the station's outer hull and the dark beyond it. Her assistant was waiting. His name was Pell. He was 26 and had been working with her for 8 months and still had the particular energy of someone who believed that preparation could fix anything. She had believed that once. She sat down. The prosecution filed 3 additional documents while we were in session, Pell said immediately. He was standing. He was always standing. I've flagged the key additions. There's a mortality projection report from the Keth Institute that's going to be. Pell. He stopped. Sit down, she said. He sat. Slowly. Like someone who wasn't sure he was allowed to. Tell me something true, she said. He blinked. What? About the case. Tell me something true. Not something from the files. Not a projection or a document. Something you actually believe. He was quiet for a moment. Outside the window, the dark was very dark and very large. I believe we're going to lose, he said quietly. I've believed that since we took the case. She nodded. Good, she said. Now we can work. She worked through the night. Not on the argument. She already had the argument. She worked on something else. She worked on the judges. 7 beings. 7 species. 7 sets of institutional loyalties and personal histories and career calculations. She pulled every public record. Every vote in every session they'd ever presided over. Every procedural ruling. Every dissent. Most of it confirmed what she already suspected. But Varn Sale. The Murith elder. The one who had blinked. She dug deeper. The Murith were ancient. Older than the Keth Dominion by 400 years. They had been the dominant galactic power once. A long time ago. Before the Keth's legal tradition had become the framework that everything else ran on. Before precedent absolute had been written into the foundational code of the court. Before, in fact, the Murith had been very carefully and very legally maneuvered out of the position they used to hold. By the Keth. She sat back. She looked at her notes. She looked at them for a long time. Then she started writing something that wasn't in the original argument. Pell fell asleep at his terminal around 2 a.m. She didn't wake him. She worked until 4. Then she stood at the narrow window and looked at the dark and thought about Earth. She hadn't been back in 3 years. Too many cases. Too many preparation cycles. Too many nights in rooms exactly like this one, looking at windows exactly like this one. She thought about her mother. Who had died while Nadia was preparing the Thelian water rights case 6 years ago. Who had asked her once, quietly, without accusation, whether she remembered why she had become a lawyer in the first place. She had said, to win. Her mother had looked at her for a moment. Then she had said, that's not what you told me when you were 12. Nadia had never asked what she meant. She had been too busy. She pressed her hand against the cold glass of the window. 8 billion people. That was what was behind her 9 documents and her 1 argument and her 19 years of wins and losses and the long, slow erosion of whatever she had been before she became the lawyer you called when it was already over. 8 billion people who were alive right now. Sleeping. Waking up. Making breakfast. Having arguments. Laughing at things. Missing people. Building things. Breaking things. Trying again. 8 billion people who had no idea this room existed. She turned back to her desk. She picked up her pen. She wrote for 3 more hours. At 7 a.m. Pell woke up with a start and immediately apologized. Don't, she said. Read this. She handed him 12 pages of handwritten notes. He read. She watched his face. He got to page 4 and looked up. This isn't the argument you told me about, he said. No. This is, you're not just defending humanity. You're challenging the foundational jurisdiction of the court to issue this class of order at all. Yes. Nadia. He set the pages down. Nobody has challenged foundational jurisdiction in this court in 600 years, she said. I know. The last person who tried was Disbarred and their entire species was fined into economic collapse for 3 generations. I know that too. He looked at her. Then why? Because they were right, she said simply. The argument was correct. The court ruled against it anyway because the court wasn't ready. Because the political conditions were wrong. Because the species making the argument had no leverage. She picked up the pages. But the argument was correct. And I found something in the archive that makes it more correct now than it was then. What did you find? She turned to page 9. There was a footnote. Old Verity legal script. She had translated it herself to make sure. He leaned over and read it. The footnote was 41 words long. In Old Verity legal script it looked like nothing. A procedural notation buried in a case record from 600 years ago. The kind of thing that gets preserved because archives preserve everything and read by nobody because nobody has a reason to look. Nadia had a reason to look. She watched Pell read it. She watched his face go through 3 separate expressions in about 4 seconds. Confusion. Then something sharper. Then the very specific look of someone doing rapid calculations and not being comfortable with where they're landing. He looked up. This says the court cannot issue a species cessation order, he said. Keep reading. He looked back down. It says the court cannot issue a species cessation order against any species that has an active, he stopped. Against any species that has an active unresolved claim registered with the Assembly's Foundational Archive. He set the pages down very carefully. Nadia. Yes. Humanity has an unresolved claim registered with the Foundational Archive. Filed 14 years ago, she said. Territorial boundary dispute. Sector 7 of the Outer Expansion Zone. It was filed, acknowledged, assigned a case number, and then put in the inactive queue because the species on the other side of the dispute, the red honey, went through a government transition and their new administration declined to pursue it. She paused. But it was never formally closed. It's still open. Still active. Still sitting in the archive with humanity's name on it. Pell stared at her. A boundary dispute about 40 kilometers of uninhabited space, he said slowly. 43 kilometers. That's the thing standing between 8 billion people and a cessation order. Technically, she said. Yes. He was quiet for a moment. They'll close it, he said. The moment you raise this, the prosecution will move to close the claim. Emergency procedural motion. It would take, he was calculating. 4 hours, maybe. 6 if we slow it down. We have 41 hours left in the deliberation window. They'll close the claim in 6. Then we're back where we started except now we've shown them our only card. Yes, she said. He looked at her notes. So this isn't the argument. No. This buys time. Potentially. For what? She stood up. Walked to the window. The dark was still dark. The station hummed around them. For the real argument, she said. At 9 a.m. she requested an emergency pre-session meeting with the court clerk. Standard procedure. Defense teams could request procedural consultations during the deliberation window. Nobody ever did. There was nothing to consult about. The process was the process. The clerk, a young Verity named Setoran who looked like he hadn't expected anyone to actually use this option, agreed immediately and looked slightly panicked. They met in a small office near the archive level. Nadia sat. Setoran sat. A recording unit activated automatically. I'm filing a jurisdictional challenge, Nadia said. Setoran blinked. Foundational jurisdictional challenge. Under archive reference, she read the case number from her notes. I'm challenging the court's authority to issue a species cessation order while an active unresolved claim exists in the Assembly's Foundational Archive bearing the defendant's species designation. Silence. Set Oren looked at his terminal. She watched him search for the archive reference. She watched him find it. She watched his face. He was young. He hadn't seen this before. But he was good at his job. She could tell by the way he read carefully instead of fast. "This is a valid archive reference," he said slowly. "Yes. The claim is, it's still open." "Yes." He looked up. "Advocate Osemensa. If I process this challenge, the prosecution will file an emergency closure motion on the underlying claim," she said. "I know. Process it anyway." He looked at her for a moment. He processed it. The prosecution's emergency motion arrived 40 minutes later. Nadia was back in the preparation suite. She read it standing up. It was exactly what she expected. Efficient. Airtight. The claim was frivolous, dormant in practical terms, and represented no substantive legal barrier to the court's jurisdiction. Motion to close. Immediate resolution requested. She had 40 hours left. She filed her response. Her response was 60 pages long. Pell read it in 2 hours. "You're not arguing against closure," he said. He sounded like someone walking carefully on uncertain ground. "You're arguing that the motion to close requires a full procedural hearing." "Yes." "You're arguing that an emergency closure motion on a claim involving an emerging species subject to active extinction proceedings constitutes a," he checked the page, "a prejudicial procedural act that itself requires independent review." "Yes. This is going to take at least 18 hours, she said. "If I file the supporting documentation correctly." He put the papers down. "And then we have 22 hours left. 22 hours and the real argument." He looked at her. "Are you going to tell me what the real argument is?" She was writing something. She didn't look up. "Not yet," she said. "Nadia." "Because I don't have it yet," she said. "I know the shape of it. I know where it lives. I need something I don't have." "What do you need?" She was quiet for a moment. "I need Varnsale," she said. Requesting a meeting with a sitting judge during active proceedings was not technically illegal. It was, however, the kind of thing that ended careers. Judges didn't meet with defense advocates during deliberation windows. It wasn't written anywhere that they couldn't. It was written everywhere in the unspoken architecture of how things worked that they simply didn't. Nadia sent the request anyway. She sent it through the formal channel. Logged. Recorded. Completely visible. She wrote 3 sentences. She did not explain what she wanted. She cited only the deliberation window's provision for extraordinary procedural consultation. A provision that had not been invoked in, she had checked, 114 years. She sent it at noon. At 12:43 p.m. she received a response. Consultation granted. Archive level 3. 1400 hours. Pell stared at the message over her shoulder. He said yes, Pell said. Yes. Judges don't say yes. This one did. Pell was very still for a moment. "He knows something," he said. "Yes," she said. "I think he's been waiting a long time to say it to someone who could use it." Archive Level 3 was the oldest part of the station. The court had been rebuilt twice in its history. The archive levels had never been touched. The corridors were narrower here. The lighting different. The materials older in a way you could feel rather than see. Varnsale was already there when she arrived. He was older in person than in his official records. The Murith aged differently than most species. Not in the ways you expected. Their faces stayed relatively constant. But their eyes deepened. Settled. Like something that had been moving for a very long time and found a place to be still. He did not stand when she entered. He did not bow. He looked at her with the direct assessment of someone who had spent centuries deciding whether people were worth his time. She sat across from him. Neither of them spoke for a moment. "You know why I'm here," she said. "I know why you think you're here," he said. His voice was slow. Deliberate. Each word chosen. "You think you found something in the archive." "I did find something in the archive." "You found a footnote," he said. "A procedural notation from 600 years ago. In a case called the Vethsoren matter." She went very still. The Vethsoren matter. She hadn't connected the case name. She had found the footnote in a secondary citation. She hadn't traced it back to the original case. She kept her face still. "Tell me about the Vethsoren matter," she said. He looked at her for a long time. Outside the narrow archive window the dark was very dark and very large. "The Vethsoren," he said quietly, "were a species. Not unlike your humans. Emerging. Volatile by some measures. Full of what the Keth Dominion's legal tradition would classify as systemic risk factors." He paused. "The court issued a cessation order 600 years ago. The case was prosecuted by the Keth Dominion. The order was executed." "The Vethsoren are gone," Nadia said. "Yes. And the footnote was written by the dissenting judge," Varnsale said. "The only judge who voted against the order. A Murith elder." He looked at his hands. "My grandmother." The archive was very quiet. "She argued that the court had no foundational jurisdiction," Nadia said slowly. "Without an unresolved claim." "She argued something larger than that," Varnsale said. "The unresolved claim was the door. She was trying to get to what was behind the door." He looked up. "She lost. She was removed from the bench. The Murith were fined. The record was buried." His voice was steady. "But the argument was correct. It has always been correct. And the Keth Dominion has spent 600 years making sure nobody went looking for that footnote." Nadia's heart was moving faster than she wanted it to. "What was behind the door?" she said. He reached into his robe. He placed a document on the table between them. It was old. Physically old. Printed on archive material that hadn't been used in centuries. "My grandmother kept a copy," he said. "The full argument. Not the footnote. The argument itself." He slid it across the table. "I have been on this bench for 30 years. I have been waiting 30 years for a defense advocate desperate enough and thorough enough to find that footnote." She looked at the document. She looked at him. "Why didn't you come forward yourself?" she said. Something moved across his face. Old. Heavy. "Because a judge cannot make arguments," he said. "A judge can only rule on them." He nodded at the document. "You have 19 hours. Make the argument. Make it correctly. Make it so I can rule on it." She picked up the document. She stood. "One question," she said. He waited. "Your grandmother," she said. The dissenting judge. "What was her name?" He was quiet for a moment. "Marinsol," he said. "She was back in the preparation suite by 1500 hours. She locked the door. She sat at the table. She opened the document. She read for 4 hours without stopping. Pell brought food at some point. She didn't touch it. He read over her shoulder for a while. She heard him go very quiet at page 11. She heard him sit down slowly at page 19. At page 27 she stopped. She looked at the wall. "Pell," she said. "Yes. This doesn't just defend humanity." "No," he said quietly. "This reopens every cessation order the court has ever issued." "Yes. Every species the court has ever," she stopped. "The Vethsoren. Whatever came before them." Everything. Yes. She sat with that for a moment. 8 billion people. And behind them, the ghost of every species that hadn't had a Nadia Ose Mensa. Hadn't had a footnote. Hadn't had 19 years of losing that taught you exactly how to find the one thing that could win. She picked up her pen. How many hours, she said. Pell checked. 17, he said. She started writing. At 3 a.m. station time, Advocate Senvorel received an alert. The defense had filed a new motion. He read the title. He read it again. He sat very still for a long time. Then he did something his staff had never seen him do in 400 years of practice. He picked up his personal communicator. He called the chairman of the Keth Dominion directly. The call connected after 2 seconds. "We have a problem," Senvorel said. There was silence on the other end. Then, "How large?" Senvorel looked at the motion title again. "Extinction level," he said. They came for her at 4 a.m. Not enforcement officers. Nothing that obvious. 2 beings in unmarked administrative uniforms. Carrying a single document in a sealed case. The kind of seal that meant the document inside had been generated at a level of authority most people never interact with directly. They knocked twice. Formally. The knock of people who know the door will open. Pell opened it. They looked past him at Nadia. "Advocate Ose Mensa," the taller one said. "You are hereby notified of a formal complaint filed against your conduct in these proceedings. Pending review, your court access credentials have been suspended." Pell made a sound. Nadia put her pen down. "On what grounds?" she said. "Improper contact with a sitting judge during active proceedings." She had expected this. She had expected it the moment she walked out of Archive Level 3 with Marinsol's argument under her arm. She had expected it and prepared for it, and she was still tired in a way that went past her bones. "The consultation was filed through the formal channel," she said. "Logged. Recorded. Fully visible. The complaint has been filed regardless. Pending review." "How long is the review process?" The taller one paused. A small pause. The pause of someone delivering a message they were told to deliver and hoping the recipient wouldn't ask the questions with obvious answers. "Standard review is 14 hours, he said. She did the arithmetic. 14 hours. She had 17. That left 3. 3 hours to make a foundational jurisdictional argument that had never succeeded in 600 years. In a court that had just been handed a reason to remove her from the room entirely. "The complaint was filed by the prosecution," she said. "Not a question." The taller one said nothing. Which was the answer? She picked up her pen. "I'll need the formal complaint documentation," she said. "Full text. Unredacted. I have the right to review the specific charges before my credentials are suspended." Another pause. "That is, technically correct," he said. "I know it's correct," she said. "I know because I've been practicing law for 19 years and I have personally filed 17 credential complaints and I know exactly what the procedural rights are on the receiving end." She looked up. "Full text. Unredacted. You have 30 minutes to produce it or the suspension itself becomes procedurally invalid." They left. Pell closed the door. He turned around. "Nadia. Get me the Assembly's procedural code," she said. "Sections 40 through 60. And make more coffee." The complaint documentation arrived in 28 minutes. She read it in 11. It was good work. She gave them that. Senvorel's team had constructed it quickly and constructed it well. The complaint cited 3 specific provisions. Her consultation with Varnsale violated the spirit of judicial independence even if not the letter. There was precedent, thin precedent, but precedent, for credential suspension in analogous situations. The argument was not airtight. But it didn't need to be airtight. It needed to be good enough to hold for 14 hours. Good enough to keep her out of the courtroom while the prosecution filed to close the unresolved claim and dismantle the procedural scaffolding she'd spent 2 days building. She looked at the 3 provisions they'd cited. Then she looked at Section 47 of the Assembly's Procedural Code. Then she looked at Section 52. Then she sat back and closed her eyes for 30 seconds. "Hell," she said. "Yes. The credential suspension requires sign-off from the court's presiding administrative judge." "Right. Who is the presiding administrative judge this session?" She heard him check. Silence. "Varn Sale," he said quietly. She opened her eyes. "The prosecution filed a complaint that requires sign-off from the judge they're trying to discredit," she said. Pell was very still. "They moved too fast," he said. "They moved too fast," she agreed. 400 years of winning makes you sloppy at 3 in the morning. She picked up her pen. She wrote a 4-page response to the credential complaint. Methodical. Surgical. She didn't argue against the suspension aggressively. She simply noted the procedural requirement for administrative sign-off and formally requested confirmation that the correct process was being followed. She filed it at 4:51 a.m. She sent a copy to Varn Sale's office directly. Then she went back to Marin Sol's argument. At 6 a.m. she stood at the window. The dark outside was starting to change. The station was moving slowly relative to a distant star and the light was shifting. Not sunrise. Nothing so human as that. But a change. Something moving toward something else. She thought about Marin Sol. A Murith elder sitting in a courtroom 600 years ago. Watching a species be sentenced. Knowing the argument that could stop it. Making the argument. Losing. Being removed from the bench. Her species fined. Her full argument buried in the deep archive and replaced with a footnote that was just small enough to survive. What did that feel like? To have the right argument and watch it fail anyway. To be correct and lose. She knew that feeling. She had felt it 7 times in the last 2 years. She had felt it the day her mother died while she was in a preparation suite not unlike this one, working on a case that ultimately settled for terms that could generously be called inadequate. She turned back to the desk. She looked at Marin Sol's argument. 29 pages. Written in old Verity script that she'd been translating line by line through the night. Dense. Careful. The work of a mind that had spent a lifetime in this court and knew exactly where the foundations were weakest. The core of it was simple. Almost shockingly simple. The Galactic Court derived its authority from the Assembly's founding charter. The founding charter established the court's jurisdiction over disputes between recognized parties. A species cessation order was not a dispute resolution. It was a unilateral elimination. The court had been issuing cessation orders for 600 years under an authority the founding charter had never actually granted. The court had simply started doing it. And nobody had successfully stopped them. An unrepeated power becomes assumed power and assumed power becomes precedent and precedent becomes law, and after 600 years the law looks so settled that challenging it feels like arguing that the sky shouldn't be dark. But the sky was dark because the station was between the star and the light. Move the station and everything changes. Marin Sol had tried to move the station. She had been removed from the bench before she got there. Nadia was going to try again. She had 13 hours. At 8 a.m. the credential suspension was formally denied. No explanation given. Administrative sign-off withheld. Pell brought her the notification with the expression of someone trying not to show how relieved they were. She read it. Set it aside. Kept writing. At 9 a.m. the prosecution filed an emergency motion challenging the sign-off denial. She had expected that too. She filed a response before noon. 14 pages. Citing every procedural protection for administrative judicial decisions. Slow. Careful. Designed not to win cleanly but to grind. Every hour she kept them in procedural skirmishes was an hour closer to the session. At 1 p.m. Pell found her something she hadn't known to look for. He had been in the archive level all morning. She had sent him to check the original Vethsoren case record. Full text. Not the footnote. Not the secondary citations. The full original record. He came back looking like someone who had found a room they weren't supposed to find. He put a single page on the table in front of her. The Vethsoren case, he said. Original session record. Page 1. She looked at it. The prosecution in the Vethsoren case, she said slowly. Yes. Was the Keth Dominion. Yes. And the charge was existential contamination. Yes. She looked up at him. The same charge they filed against humanity, she said. Word for word, Pell said. I checked. It's not similar. It's identical. Same language. Same structure. Same supporting framework. He sat down. They've used this before. Against the Vethsoren. They refined it. They filed it again. She thought about the Keth Dominion. 400 years of Senvoral. A legal tradition older than humanity's writing. A species that had spent 600 years building a framework so complete and so settled that nobody looked underneath it anymore. The final argument was 41 pages. She read it through once at 7 p.m. Made 3 corrections. Read it again. Pell read it in silence beside her. When he finished he didn't say anything for a while. This doesn't just challenge the cessation order, he said finally. This challenges the legitimacy of everything the court has built on top of it. Every ruling that cited the Vethsoren case as precedent. Every expansion of jurisdiction that followed. Yes. The court has issued 19 cessation orders in 600 years. Yes. If this argument succeeds. Every one of them is void, she said. Every species eliminated under an authority the court never legally had. She paused. Most of those species are gone. You can't bring them back. But you can establish that the court never had the power. You can make sure it can never happen again. Pell was quiet. This is going to terrify them, he said. Yes. They're going to fight it with everything. Yes. Nadia. He turned to look at her. If this fails. I know. Not just humanity. If this fails, the court will reinforce the precedent harder than ever before. They will close every gap. They will make it impossible to. I know, she said. So why? She looked at him. Because it's correct, she said. The argument is correct. Marin Sol was correct 600 years ago. She just didn't have what we have. What do we have? She looked at the 41 pages. The original Keth prosecution documents from the Vethsoren case, she said. Identical language. Identical charge. Provable pattern. She paused. And a judge on the bench whose grandmother wrote the argument we're about to make. Pell looked at the pages. Then at her. 2 hours, he said. 2 hours, she agreed. She stood up. Straightened her jacket. Looked at herself briefly in the dark reflection of the window. She looked tired. She looked exactly as tired as she was. She picked up the 41 pages. At 9 p.m. station time the deliberation window closed. Formal proceedings were called to order. Advocate Senvoral entered the courtroom first. He moved with the particular ease of 400 years of certainty. He did not look at the defense table. Nadia entered 30 seconds later. She placed 41 pages on the table in front of her. She looked at the bench. 7 judges. Varn Sale, on the far left, looked back at her. He did not blink. He nodded. Once. So small that nobody else in the room would have seen it. She saw it. She sat down. She thought about Marinsol. She thought about 8 billion people who were alive right now and had no idea this room existed. She thought about her mother. About being 12 years old and knowing, with the uncomplicated certainty that children sometimes have before the world teaches them better, exactly why she wanted to be a lawyer. Not to win. To make it right. The chief judge called the session to order. Nadia stood up. The defense, she said clearly, moves to challenge foundational jurisdiction. The room went very still. Senvoril turned and looked at her for the first time. She looked back. She did not look away. The room stayed still for 4 seconds. Nadia counted them. In a court that had operated for 6,000 years, 4 seconds of complete silence was not nothing. It was the sound of something very large and very settled shifting slightly on its foundations. Then Senvoril stood up. He moved the way he always moved. Unhurried. Precise. The movement of something that has never needed to rush because the outcome has always been predetermined. But his eyes were different now. She had studied his eyes for 6 weeks. In recordings. In transcripts. In the careful archival footage of 11 consecutive victories. She knew exactly what his eyes looked like when he was performing certainty. This was not that. This was actual certainty facing something it hadn't prepared for. And actual certainty, she had learned, was far more dangerous than the performed kind. The defense's motion, he said, is procedurally irregular, historically unprecedented, and fundamentally without merit. He paused 1 beat. The court's authority to issue species cessation orders is established by 600 years of consistent practice. It has been cited in 47 subsequent rulings. It forms the foundational bedrock of this court's jurisdiction over existential threat proceedings. He looked at Nadia. Challenging it at this stage of proceedings is not a legal argument. It is a delay tactic dressed in archive clothing. The chief judge looked at Nadia. Defense will respond, she said. Nadia stood. She did not look at her notes. She had read the 41 pages so many times through the night that they lived in her now. Not memorized. Absorbed. The way you absorb something that has been true for a long time and you just didn't know it yet. The prosecution says 600 years of practice, she said. I want to talk about what that practice. The room stayed still for 4 seconds. Nadia counted them. In a court that had operated for 6,000 years, 4 seconds of complete silence was not nothing. It was the sound of something very large and very settled shifting slightly on its foundations. Then Senvoril stood up. He moved the way he always moved. Unhurried. Precise. The movement of something that has never needed to rush because the outcome has always been predetermined. But his eyes were different now. She had studied his eyes for 6 weeks. In recordings. In transcripts. In the careful archival footage of 11 consecutive victories. She knew exactly what his eyes looked like when he was performing certainty. This was not that. This was actual certainty facing something it hadn't prepared for. And actual certainty, she had learned, was far more dangerous than the performed kind. The defense's motion, he said, is procedurally irregular, historically unprecedented, and fundamentally without merit. He paused 1 beat. The court's authority to issue species cessation orders is established by 600 years of consistent practice. It has been cited in 47 subsequent rulings. It forms the foundational bedrock of this court's jurisdiction over existential threat proceedings. He looked at Nadia. Challenging it at this stage of proceedings is not a legal argument. It is a delay tactic dressed in archive clothing. The chief judge looked at Nadia. Defense will respond, she said. Nadia stood. She did not look at her notes. She had read the 41 pages so many times through the night that they lived in her now. Not memorized. Absorbed. The way you absorb something that has been true for a long time and you just didn't know it yet. The prosecution says 600 years of practice, she said. I want to talk about what that practice looked like, consequences. Destabilizing the legal order that has maintained galactic peace for 6,000 years, in order to protect one species, is not justice. It is recklessness. He sat down. The room absorbed this. It was a good argument. She knew it was a good argument because she had written the response to it at 2 a.m. and even then, tired and running on cold coffee, she had felt how good it was. She stood. The prosecution asks the court to consider consequences, she said. I agree. Let's consider them. She had one document left. She placed it on the panel. This is a record of every species that has disappeared from the Galactic Registry in the last 600 years, she said. 47 species. Some through natural causes. Some through conflict. Some through choices their own civilizations made. She paused. And 19 through cessation orders issued by this court. She let the number sit. 19 species, she said. Gone. Under an authority this court was never granted. The prosecution asks what chaos looks like if we correct this error. She looked at the bench. I would ask the court to consider what it looks like if we don't. I would ask the court to look at that list and understand that each of those 19 species had a defense advocate who stood in this room and made arguments and lost. Not because the arguments were wrong. Because the framework was broken. Because the foundation was built on a case where the dissenting judge was removed before she could finish speaking. She looked at Varn Sale. He was looking at the document panel. At the list of 19 species. His grandmother's name was on the case that started it. The prosecution says correcting this error creates chaos, she said quietly. But leaving a broken foundation in place is not stability. It is a building waiting to fall. The question is not whether we can afford to fix it. The question is whether we can afford to keep pretending it isn't broken. She sat down. Senvoro made 3 more arguments. Each one was good. Each one was the work of 400 years of practice and precision and an intimate knowledge of this court's rhythms and tendencies and pressure points. She answered each one. Not perfectly. She felt the moments where her responses were thinner than she wanted. Where the legal architecture had gaps she hadn't had time to fill. Where a sharper mind with more time might have found weaknesses. But she answered. And each time she answered she felt something in the room change slightly. Not dramatically. Not the way it changes in stories. Small. Real. The way actual things change, incrementally, almost invisibly, until you look back and realize the room you're in now is not the room you started in. At 11 p.m. the chief judge called a recess. 40 minutes. Nadia sat at the defense table and did not move. Pell appeared beside her from the gallery access. He sat down. He didn't say anything for a while. The bench has been conferring, he said quietly. I know. Varn Sale hasn't moved. I know. He's been looking at the document panel. She looked at the panel. The list of 19 species was still displayed. 47 names in total. Most of them in scripts she couldn't read. She thought about what it meant to be a name on a list. To have been a civilization. To have had gardens and arguments and people who laughed at things. To have had children who pointed at the sky. To have been reduced to a line in an archive that nobody looked at. Pell, she said. Yes. Whatever happens in the next hour, she said. I need you to know that the argument was correct. Marin Sol was correct. And we said it out loud. In this room. In the record. She paused. That exists now regardless of what they rule. Pell looked at her. It's going to work, he said. She looked at the list. Maybe, she said. The recess ended. The judges returned. Nadia stood. The chief judge looked at the bench. Then at the room. Before the court issues its ruling on the jurisdictional challenge, she said. Judge Varnsale has requested to make a statement. Senvorel went completely still. Varnsale stood. He was old. In person and in this moment both. The weight of 30 years on this bench and 600 years of his grandmother's unanswered argument and 19 species on a list sat in his posture. He looked at the room. Then he spoke. He spoke for 11 minutes. Nadia did not take notes. She listened. He spoke about the founding charter. About the original intent documented in the pre-court assembly records. About the distinction between dispute resolution and unilateral authority that the charter's authors had been explicit about in their preparatory documents. He spoke about the Vethsoren case. He spoke about his grandmother. He did not perform emotion. He was Murith. They didn't perform. But something was present in his voice that had weight. That had been carried a long time. He spoke about a judge who had been correct and been removed and whose full argument had survived in one handwritten copy kept in a family archive for 600 years. He spoke about what it meant that the argument was still correct. That correct arguments don't expire. That the passage of time doesn't make a broken foundation solid. That 600 years of building on top of a structural error doesn't justify the error. It makes fixing it more necessary. Not less. When he finished he sat down. The room was very quiet. The chief judge looked at the full bench. The court will vote on the jurisdictional challenge, she said. 7 judges. The vote went down the bench from right to left. 4 votes first. All against. Each delivered with the particular firmness of people who had already been part of this structure for too long to easily dismantle it. Nadia counted. 4 against. 2 remaining. Varnsale last. The 5th judge voted. Against. 4-1. She needed a majority. 4 votes. She had 1. The 6th judge. The room held its breath in the specific way rooms do when everyone knows the next thing matters. The 6th judge was a Kalesai elder. Old. Appointed 12 years ago. Nadia had reviewed her record. 40 years on various benches. 3 dissenting votes in her career. All 3 on procedural grounds. All 3 later vindicated. She looked at the document panel. At the list. She voted. Yes. 4-2. Varnsale. He did not pause. He did not perform consideration. He voted the way someone votes when they have been waiting 30 years to vote. Yes. 4-3. Not a majority. The challenge failed. Nadia sat very still. She heard the chief judge begin to speak. Something about the ruling being recorded. About proceedings resuming. About the prosecution's original motion being. Wait. The word came from the gallery. Not loud. But clear. And from a direction nobody expected. Everyone turned. In the observation gallery, in the 3rd row, a being was standing. Old. Murith. Not a delegate. Not a journalist. A civilian visitor badge visible from where Nadia sat. She had never seen this being before. The chief judge looked up sharply. The gallery will remain. I am Advocate Soral Ven, the being said. Retired. 40 years of practice in this court. She looked at the bench. I am registering formal intent to file an amicus submission on behalf of 11 retired advocates of this court who have reviewed the defense's jurisdictional argument and wish to enter the record in support of it. Silence. This is highly irregular, the chief judge began. Section 88 of the court's procedural code, Soral Ven said. Allows retired officers of the court to submit amicus filings during active proceedings when foundational jurisdictional questions are raised. She paused. I looked it up last night. After someone sent me 41 pages at 3 in the morning. Nadia looked at Pell. Pell had the expression of someone trying not to smile and failing. She looked back at the gallery. 11 retired advocates. She had sent the argument to 12 locations. She had forgotten she'd sent one to a retired advocate directory. An old contact. Someone who had been practicing when she was still in law school. She had forgotten. She hadn't forgotten. She looked at her hands. The chief judge was conferring with the bench. Senvorel was standing. Filing something. His voice was raised for the first time all night. Nadia sat quietly and watched it happen. The room was moving now. Properly moving. The way things move when a foundation shifts and everything built on top of it has to find a new position. It was loud. Complicated. Procedurally messy. It was exactly what 600 years of settled law looked like when someone finally asked the question it had been built to prevent. Pell leaned close. 11 advocates, he whispered. The amicus filing makes it a formal record. They can't just rule and move on. They have to address it. Fully. On the record. Yes, she said quietly. This goes to the full assembly. Yes. That takes months, she said. Maybe longer. She looked at the bench. At Varnsale, who was watching the room with the stillness of someone who has just put down something very heavy. But humanity doesn't get a cessation order while a foundational challenge is under full assembly review. Pell was quiet for a moment. You planned this, he said. The 41 pages. Sending it to 12 locations. The retired advocate directory. She looked at him. I planned for the possibility that 3 votes wasn't enough, she said. And that sometimes the argument needs more voices than one exhausted lawyer in a preparation suite at 3 in the morning. He looked at her. You learned that from losing, he said. She thought about 7 consecutive losses. About a mother who asked a question she never answered. About being 12 years old and knowing something that 19 years of practice had almost buried. Yes, she said. I did. The formal session ended at 1 a.m. without a ruling. By order of the chief judge, proceedings were suspended pending full assembly jurisdictional review. Humanity's cessation order was placed on indefinite hold. Advocate Senvorel filed 4 motions before dawn. All 4 were placed in the review queue. Varnsale submitted his formal written statement to the Assembly archive at 2 a.m. He cited his grandmother by name. For the first time in 600 years her full argument entered the official record. At 3 a.m. Nadia sat in the preparation suite. The 41 pages were on the table in front of her. Pell had gone to sleep finally. The room was quiet. She looked at the pages for a long time. Then she picked up her pen. She wrote one line at the top of page 1. She didn't know why. It just needed to be there. For Marinsol. Who was correct? She put the pen down. She looked at the window. The dark was still dark. But the station was moving. Slowly. Toward the light. The finale. The assembly chamber was the largest room Nadia had ever stood in. Not just physically. It was large the way history is large. The way a place feels when you understand that every significant decision made in this part of the galaxy for 6,000 years had been made inside these walls. Treaties. Wars ended. Species recognized. Borders drawn. And at least 19 times, species erased. She stood at the advocate's podium and looked up. 412 seats arranged in a rising arc, representatives of every recognized species in the Galactic Registry. Most of them full. Some of them filled by beings who had traveled weeks to be here. The gallery above held 3 times that number. She had never spoken to a room this size. She had prepared for this for 6 weeks. She was not ready. She stood at the podium anyway. The review had taken 4 months. 4 months of filings and counter-filings. 4 months of the Keth Dominion's legal apparatus working at full capacity to contain what had started as a 41-page argument in a small preparation suite at 3 in the morning. They had tried everything. They tried to have the amicus submissions invalidated. Failed. They tried to have Varnsale's statement struck from the record on grounds of judicial impropriety. Failed. They filed a motion arguing that the Assembly lacked authority to review the court's foundational jurisdiction. That motion lasted 6 days before the Assembly's own legal counsel dismantled it. They tried to have Nadia's credentials permanently revoked. That one came close. It came close enough that she had spent 2 weeks in genuine uncertainty. Not performed uncertainty. Real uncertainty. The kind that sits in your chest at 4 a.m. and doesn't respond to logic. Pell had found her in the preparation suite on the worst night. He hadn't said anything. He had just sat down across from her and stayed there until morning. She had not thanked him adequately for that. She made a note to fix that after today. The credentials challenge was ultimately dismissed. Procedurally flawed. The Keth Dominion's team had moved too fast again. 400 years of winning had not taught them how to fight someone who had nothing left to lose. She had learned that from losing. 4 months of procedural warfare. And now this room. The Assembly's legal counsel had spent 6 weeks reviewing the foundational challenge. Their report was 300 pages. She had read all of it. 3 times. She knew where it was strong and where it was careful and where it was deliberately quiet about things it wasn't ready to address directly. The council's finding had been cautious. Carefully, precisely, professionally cautious in the way of institutions that have been built to move slowly and intend to keep moving slowly regardless of what is burning around them. They found that the jurisdictional question raised legitimate concerns requiring further deliberative process. Not a ruling. Not a decision. A finding that the question was legitimate. In 6,000 years of galactic legal history nobody had found a jurisdictional question legitimate before. It was not enough. But it was a door. Today she was walking through it. Senvorel was already at the opposing podium when she arrived. 4 months had not changed him visibly. He was exactly as composed as he had been in the court. Exactly as still. But he had looked at her immediately when she entered. He looked at her now. She looked back. She thought she understood him better now than she had 4 months ago. She had spent time with that understanding. He was not a villain. He was something more complicated and in some ways more difficult to argue against. He believed what he was doing. He genuinely believed the galactic order he had spent 400 years building and defending was worth defending. That stability mattered. That the framework mattered. That some costs were acceptable to preserve something larger. He was wrong. But he believed it. And people who genuinely believe something are harder to argue against than people who are simply corrupt. Because you cannot appeal to their conscience. You have to appeal to something deeper than belief. You have to appeal to what the belief was always supposed to be for. She turned to face the chamber. The presiding assembly delegate called the session to order. The legal counsel's findings were formally entered into the record. Then she was given the floor. She stood at the podium. 412 seats. 3 times that in the gallery. 8 billion people who had no idea this room existed. She thought about her mother. She thought about being 12 years old. Sitting in a waiting room with her mother outside a government office. Watching a man behind a desk tell a woman, quietly, professionally, with the particular cruelty of people who have learned to deliver bad news without feeling it, that her case had been closed. That the decision was final. That there was nothing more to be done. The woman had 2 children with her. Both small. Both watching their mother's face. 12-year-old Nadia had watched the man go back to his papers. Watched the woman stand and take her children's hands. Watched the door close. She had turned to her mother. Why didn't someone stop that, she had said. Her mother had looked at her for a moment. Someone could, she had said. If they knew the right words in the right room. Nadia had decided something in that moment. Not to win. To know the right words. To find the right room. She looked at 412 seats. She had found the room. She spoke for 40 minutes. She did not use notes. She began with the founding charter. Not the legal argument. The history of the founding charter. Why it was written. What the beings who wrote it had been trying to build. She had spent 2 weeks in the Assembly's founding archive. She had read the original debates. The original disagreements. The original arguments about what this body was supposed to be for. She read one passage aloud. Written 6,000 years ago by the Assembly's first presiding delegate. In the founding record. Page 3. She had the original on the evidence panel. And the translation beside it. We build this body not to govern species but to protect them. Not to determine which civilizations deserve to exist but to ensure that existence itself is never again subject to the will of the powerful over the vulnerable. This assembly's first and final purpose is to stand between any species and erasure. She let it sit. If you liked this journey through the stars, hit subscribe and join us for the next adventure. Until then, stay curious, stay brave, and keep looking up.